everyone. Welcome to our webinar this afternoon, Applying for a Grant of Aid and Navigating our Application Process. Welcome. I'd like to start by acknowledging the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. So again, welcome everybody. My name is Catherine Gorda. I'm the Community Legal Education and Engagement Coordinator here at Legal Aid. Apologies that I'm off screen at the moment. Sitting next to me is Katrina Smith, who's our Executive Director, Information Advice and Partner Services, and Leanne Parker, who's our Director of Grants. Welcome to you both, and thank you so much for giving your time to present today. Before we kick off with the webinar content today, there's a little bit of housekeeping to be run through. So just to remind you all that this webinar is being recorded, and we'll make sure the webinar recording is made available on our YouTube channel, hopefully in about a week's time. If you do have any IT issues with accessing the webinar sound or anything, we will need you to contact the GoToWebinar support line. So please make sure that's who you contact if you have any sound issues. We have made a copy of the PowerPoint slides available for you to download as a handout. That should be available on your screen now. You are very welcome to ask questions throughout the webinar. There's a question box you can type those into, and we'll take a look at those at the Q&A section at the end of the presentation content today. I'll just also flag we have received heaps of questions in advance when people registered. Thank you so much for that. We've shared those questions with our presenters and we've tried to answer as many as we can throughout the presentation content. So that's fantastic. Thank you so much. So I'm going to jump into our very first poll. This is just to help us get to know who's joining us today. And that poll is, where do you work? So I'm just going to launch that for you now.
Right. Thanks, Catherine. Yeah, it's great for us to know where everyone's coming to from today.
Yeah. So the first question is, what region do you work in? And the options are South East Queensland, Far North Queensland, Regional Queensland, or outside of Queensland. So I'll just give you about 5 or 10 seconds just to pop your answers in there.
Yeah. And just a reminder, it's Queensland Legal Aid that we're talking about today. So it's our processes here in Queensland that we'll be going through.
Yeah, all right, I'll close that off and share our responses.
Great.
So we've had 64% of you guys are joining us from South East Queensland, so welcome. We've got 19% from Far North Queensland.
Oh, that's fantastic.
17% from regional, and no one from outside Queensland.
Great. That's good.
Great, thank you. I'll just hide that one and move on to our next. I've got another poll for you straight up.
Yep.
So the next poll is, what is your role? So I'll just launch that for you now. So the options are support worker, financial counsellor or health education worker, social worker, lawyer or other. So I'll just give you guys 5 more seconds to do that one. So I've got quite a few lawyers joining us today. A couple more seconds. All right, I'll close that off and share the results. So we've got 39% lawyers, that's our largest category, and then a lot of social workers and a few financial counsellors and support workers as well, and also other. I won't discount others, so welcome everybody. Whatever category you're in, I'll just hide that.
Yes.
On to the next slide. Okay, at this point I'm going to hand over to Katrina to start running through her presentation. Thanks, Katrina.
Great, thanks everyone. And look, we are going to be going through a lot of stuff today. There's a lot of information, so you've got your handout there, so please feel free to take it away. And Leanne and I have done our best to try and cover all of the questions that came in beforehand, but please do feel free to put in some questions for us. We won't be able to ask specific questions about specific matters, but if you do have some specific matters that you need followed up, we can talk about how to do that at the end. So thanks, Leanne, for joining me, because grants, it's a very complicated area. So what we're going to be talking about today is applying for legal aid, the actual application process, how legal aid decides applications, what to do if you determine that your client has some special circumstances, and we'll talk through what that means. And at the end, we want to give you some tips for how to actually navigate the process, make sure that your client's application is assessed as quickly and as efficiently as possible. So many of you probably know who we are. We're Legal Aid Queensland. We're an independent statutory authority. We have our own act, the Legal Aid Queensland Act, and we're funded by the state government for specific state law matters and by the federal government for federal law matters. And pardon me, although we do receive funding from government agencies, we're independent from government, but we are not for profit, so we do rely on the funding that we're given to provide the services that we provide. And that's a really actual important thing to talk through, because we don't have much wiggle room in terms of what we fund. Most of the funding that comes to us has conditions attached about this funding is to be used for these particular legal issues. So that is probably the first thing that people need to know, right, Leanne? There's not much discretion really in terms of what we're funded to do. It'd be great to just get a little idea about how much people know about legal aid, and then we can sort of tailor our presentation as we go. So Catherine's got another poll there for you. Thanks, Catherine.
So I just launched this for everybody.
Great.
So the question is, how would you rate your knowledge of Legal Aid Queensland? So high, good, limited, or none? It's just to give us an idea of who's joining us today. And a couple more seconds on that one. All right, I'll close that off and share.
Hopefully some of you have a bit of knowledge. That'd be good.
Great to know that 30% said high knowledge.
Oh, fantastic. Oh, that's great.
50% good.
Right.
And 36% limited, and just a small percentage none. So that's great. So lots of you know what we're about, but hope you can learn a few new things today as well. But I'll hide that for you now.
Fantastic. Thank you so much. So just a little bit about us more specifically. So we've got 14 offices throughout Queensland, and we have over 700 staff working for us. Got a lot of very highly respected lawyers across a range of different types of law across Queensland. We're the largest criminal practice in Queensland, but our work also includes family law, anti-discrimination, human rights, consumer law, mental health, sexual harassment, and veterans affairs. So that work takes place in our civil law section, and they do a lot of CPD. So if you're interested in learning more about our civil law section, you should really check out it's our YouTube channel, is it?
It's fantastic. There's heaps of great webinars on there about civil law things that we help with. So.
Thanks. So what do? Well, we help people who have legal problems but can't afford to pay for a lawyer. And we are funded, and our Act specifically requires us to actually assist people who are financially disadvantaged. But we do provide free legal information to everyone, and we do that through our contact centre. People can call for information. And we also have our website, which has a lot of information, a lot of publications, brochures, pamphlets, etc. And obviously, we like to try and, where we can, to bring our expertise to the development of law and policy in Queensland. So I mentioned our website, and we've put up the number there for clients to call. So this is specifically a client number, 1300 65 1188. So we have people answering that number who can give sort of limited information, and they can also, if they determine that your client has a legal issue that requires legal advice, they can book them in for legal advice. So really, we think of the call centre, the contact centre, as our sort of first point of call for clients. And if we determine that a client actually needs a grant of legal aid, then we'll talk them through how to make that application as well. As I said, our legal services are targeted to financially disadvantaged Queenslanders, but we do have duty lawyers, and some of you may even be our duty lawyers, who are at most courts that everyone can access our services there. But if you actually determine that your client needs a lawyer to represent them beyond the duty lawyer process or beyond just getting normal information, legal information, then they do have to apply for a grant of legal aid. And that is where Leanne's section, the grants section, actually comes into play in terms of determining who gets a grant of legal aid. And obviously, because of our funding, we can't provide representation for everyone that we would like to. We do provide funding for lawyers to represent people in court mediation and negotiation, and you can see there the list of the courts that we provide funding for. But all clients must meet our tests to qualify for representation, and that's really where Leanne's going to help us work through some of those things.
And that list of courts and tribunals, that's not an exhaustive list.
No,
there are more courts and tribunals that we service. So if you need more information, there's lots of information on our website about what we fund.
Perfect. Right, so look, and this is can be quite a difficult process for people, but we do require a written application. And we have an application form. It is long and it's very detailed, isn't it, Leanne? It asks for a lot of information, not just information about the legal issue, but also information about the client's financial circumstances, and we'll go into that a little bit more. We have old school paper applications available at most courts and also at our offices, and people can also obtain them from the duty lawyer. We've got an electronic copy available online, and if you're one of our partners or your client is working with one of our partners, they can lodge the application electronically using one of our software things called Grants Online. Thanks, Catherine. All right. Now, I think this is probably you, Leanne, because this is the part that people find very difficult, right? In terms of making sure that we've got enough information to actually assess the application. So,
yeah, so I think when you are assisting a client in completing an application for aid, particularly if they are lodging that directly to us and they're not going through one of our partners, we do find they're the highest percentage of applications that aren't fully complete, or where we don't have enough information to assess the application for aid, and we have to then go to the client asking for some further information, which of course then delays the process. So if you are assisting an application to a client to complete an application for aid, some really common things that we need to make a decision are their Centrelink income statement. If your client is receiving Centrelink, we need a copy of their Centrelink income statement. I believe they're pretty easy to get from Centrelink. A lot of clients can go onto their phone and onto MyGov and download that. So please, if you can, get your client to provide that when they are applying for aid. We would really appreciate it, because it is something that we need to make an assessment. If your client's working, we do need copies of their pay slips to determine whether they're financially eligible. We normally will require 4 weeks of pay slips. If your client is someone who's a seasonal worker, for instance, that might be one where you might want to give us some more, depending on the period of their seasonal work. They might be receiving a higher amount of income. So we are able to average that out if for people who work in those seasonal or casual jobs. So the more information I think you can give to us, the better it is for your client in the end when we make that decision. If your client's self-employed, we do require copies of their tax returns, notice of assessments, that kind of thing, so that we can determine how much they earn. Those applicants are in the more complex category of assessment, so we do need as much information as you can provide so that we can work out what their average weekly income is. For all clients, we generally require their bank statements, and that's for all of the accounts that they hold and we will require that for the past 3 months. If we are looking at an application for aid and we notice lots of transactions, and a lot of our clients have multiple bank accounts, and you can see that when you're looking at bank statements. So we do ask that you provide all of the bank account statements for all accounts for the past 3 months, because there will be delays if that's not provided. Assessing officers will see that there are other accounts, and then that's something that we'll ask for. So if you can get that in the first instance, that would be really helpful. And then, of course, we need information about the legal problem they have, and this can vary depending on what you're applying for aid for. So if it's criminal law, copies of QP9, criminal history, really helpful. If it's family law, details about the family law dispute. If there's any orders in place, we would really appreciate those to be attached. If there's any, if the clients tried to go to a Relationships Australia centre to get to do mediation, a copy of the certificate is helpful for domestic violence. Copies of a protection order or any applications that have been made. They're all the kind of things that we will need when we're assessing a client's application for aid. And if you want some more detailed information, we do have a fact sheet which is targeted at our clients, which is called Can I Get Legal Aid? It's a really helpful fact sheet, and I would encourage you to provide that to your clients if they are wanting to apply for legal aid.
We can put a link to that fact sheet in the email that we send with the recording.
Great. Thanks, Catherine. Now, Leanne, before we go on, I'm just going to say we've talked a lot about a lot of documents there. Probably important for people to know what happens if we get an application that doesn't have all of that documentation.
So what we'll try to do, and it depends on the pathway of how we receive the application. So if we get the application from one of our partners, our officers might email the law firm that submitted the application or pick up the phone and talk to them. For applications that we receive directly from our clients, we will also try to pick up the phone and talk to the client and explain what we need. Sometimes that doesn't always occur, and it could be the clients don't pick up. When we do ring from private numbers, so it is common for our phone calls to not be answered. Otherwise, we do email where we can, but our system we do have some system limitations. So at the end of the day, if we can't get your client over the phone, we will send a letter to your client asking for additional information, and the letter will spell out what we need. But where we can, we will try to phone the client and have a chat with them to let them know what we need.
That's right. And if your client gets one of those letters, there'll be a number there to call, and we do have people in our client contact centre who can explain what's actually required, but obviously that creates a delay.
It does.
So it's much better if you can to get the documentation up the front, and I've just foreshadowed one of our top tips. All right, so talk us through the actual form, Leanne, and it's quite long, isn't it?
It is long, and a lot of the questions we ask are things that we need from a system perspective. There is data that we have to collect for the government, so they are important questions that we ask, and we do ask if you can please try to complete the application as best as you can, answer every question, and at the end of the form there are a couple of spots for the client to sign, and each application has to be signed. So if we don't get a signed application form, that does cause delays as well, because we do need a signed application form to provide a grant of aid. So that,
and if you've got a client that you think might need a little bit of additional assistance to complete the form, they can come into one of our offices and we can do that. It's probably the easiest way if they're able to. Otherwise, they can call through to the contact centre, but it's probably better if they can to come in person, but we know that's not always possible. But
yeah, so have a look at our website and make sure if you are assisting a client to complete an application for aid, that it is a matter that we would fund. Our grants handbook and grants policy manual is publicly available. You can have a look at the website and work out whether that's a matter that we do give grants of legal assistance for. We also detail what our criteria is and what documents we need for that specific application. So I do encourage you to have a look at our grants handbook. As I said, it is available publicly, and there's really good information there about what we need to assess an application for aid for that particular area of law and matter type, and each can be different. and we've got a lot of different things that we can fund. So I do encourage you to have a look there. If your client sees one of our lawyers that partners with us, so we call them preferred supply firms, well, there is a list on our website as well about who partners with us. So you can also direct the client to one of our partners, and they can assist the client to complete the form as well on their behalf. If your client doesn't have a solicitor, they can send the application directly to us. So there's an email address there on the PowerPoint slide. They can also hand deliver it to one of our front counters or put it in the snail mail to us as well.
That's right. And if you do have a client who you think does need some assistance and can't come into the office, we can identify that over the phone. So the best thing to do is call through on that 1300 number. We'll identify that and we'll make some arrangements internally to assist them. So just a note to self. So yes, there's that number again. Great, 1300 65188. So that's for people who haven't yet applied for legal aid, who've got a legal issue, who aren't sure whether they'll be eligible for legal aid, who might just need a bit of information. If your client has actually already put in an application for aid, they're waiting to hear what's happened, they're not sure what's going on, that other number 1300 383 900 is the number for them to call, and we'll be able to look up the application and help them with where it's at. Great. Now, client authorities, this is particularly important for those of you who are assisting clients who aren't lawyers or who are, family members, carers, supporters. It is tricky, isn't it, Leanne? Yeah. We're bound by a lot of privacy regulations and also client confidentiality rules. So we really can't talk to anyone but the client about their legal aid application, and that can be a problem for people who are supporting someone, can't it, Leanne?
It can be, yes. We do have a client authority form.
Yeah.
So if your client needs additional assistance and they want us to speak with someone that they provide authority to, then we encourage you to fill out that form as soon as you can and submit that with the application for aid.
That's right.
So that we can speak to the person who can help the client at the end of the day. So if you're a social worker, you're assisting a client and they give you authority, we can then have a conversation with you if we need any additional information for you to then help the client provide that to us.
And that's sort of in an ongoing way though, right, Leanne? So for people who might have someone in their office, for example, who might need a little bit of help to communicate with legal aid, we can talk to you provided the client's there and gives us that authority just for that phone call. We might be able to assist with explaining process and things to you so that you can explain them to the client. We're happy to do that, but we need the client to authorise us to do that.
Yeah, we can definitely take a verbal authority from the client. And and I think it's important to note that the client authorities are file specific as well.
Mm-hmm.
So for each new matter that potentially your client is involved in, they will need to recomplete that form. It's not an ongoing authority for for all dealings with legal aid. They have to provide their authority for each matter.
Great. So if, for example, they had a family law matter and a criminal law matter, they need an authority for both of those.
Yes.
Okay, great. Yeah, thanks. Oh, right, now this is the big ticket item, Leanne, isn't it? And look, I think this is very complicated, isn't it, about what we fund when we fund. We've got a very comprehensive grants manual that's available on our website, but it is tricky. So we are going to get into sort of a bit of the minutiae now really about how we actually make those determinations. And as I said, our funding priorities aren't set by us, they're set by the funding that we receive. And we do have very high demand for our services. So when we're trying to work out how we will allocate funding, we do use a set of guidelines and criteria, and thank goodness Leanne's here to help us go through those. Leanne, what are the criteria? Yeah.
And look, we don't have enough time to go through everyone.
Yes.
There are a lot, and as we've already touched on, it really depends what your matter, what type of matter your client is applying for legal aid for. So the test can vary depending on the matter type. So I do want to make that really clear.
Yes.
This is going to be quite a general conversation about our tests, but each one is different. So I do encourage you to have a look at our grants policy manual on the website for specific types of matters. But essentially, a grant of legal aid is not an automatic entitlement. So one of the common misconceptions is that if a client is receiving Centrelink benefits, that they will receive a grant of legal aid appointing a lawyer. Unfortunately, it's not an automatic entitlement just because you're on Centrelink. We have 3 different tests that we apply when assessing an application for aid. So those tests are our guidelines test, our means test, and in most cases we will also apply a merits test. So to get a grant of aid, you must meet all the criteria, and it depends what type of matter you're applying for. Some matters there might not be a merits test, or the means test might not apply. For instance, for children, the means test doesn't apply. So it really depends on the client and the matter. For us to know what tests apply, and the grants policy manual provides guidance on that issue. So we'll go into the means and merits test now. And so the means test is our cornerstone test. We are here to provide grants of legal representation to clients who are financially disadvantaged. So how do we do that? We have a means test, which looks at what a person earns and what assets they own. So about 80% of people who receive legal aid are often unemployed and in receipt of a government pension from Centrelink. Our means test is available on our website. You can see that there's a picture of the means test there.
Mm-hmm.
That is the means test is documented in our grants policy manual. So if you want further information outside of the session today, go onto the website and have a look at the means test. It provides all of the information you need to know about what we look at. But how does the means test work? The means test for financial eligibility looks at a number of things. So we look at the income of the client and any person who helps them financially, the assets of the client and any person who looks after them financially, and also we take into consideration how many people they support. So that could be people, so if you've got dependent children, the means test takes that into account, and if you're partnered, again, it takes that into account. So essentially the means test is we're looking at income and assets, and we do factor in things like if someone's got children or a partner.
And people might not know that, but we do need people's partners' information, don't we, Leanne? And I think that that's something people might not be expecting when they go to apply for legal aid, but we're looking at all of the financial I guess assistance that's available to the client.
And the way I think about it is when you go and do your tax return and you're filling out your income for the year and answering questions of ATO, essentially we are asking similar questions. Yeah. So what kind of income should be included in an application? We're looking at salaries, wages, any money that the client receives from other sources. So if, you know, from an investment point of view, if the client has shares and receives dividends, if they have a rental property and they receive rent for that property, if they have a trust account and receive payments from the trust, and also if the client's receiving income through an insurance policy claim, such as something like work cover, then that's when we're looking at income, that's what we're looking at. We also look at Centrelink income. So if you're a client, if you're receiving Centrelink but also are working, we will look at the Centrelink income that you earn, and that includes your family tax benefits, Part A and B. We will also look at any child maintenance and child support payments, and that is classed as income when we're looking at a client's income as a whole. But generally speaking, a lot of our clients are in receipt of Centrelink payments, and applicants who rely on a full Centrelink payment for their income are deemed eligible under the income test. But it is important to note that their means test includes other tests like our assets test. So just because you're fully reliant on Centrelink, while you meet the income test, you also need to meet our assets test, and our assets tests aren't aligned with Centrelink. So you could be receiving Centrelink, but might not be eligible potentially for legal aid under our assets test.
Yeah.
So what assets are included in the means test? We look at all the assets that a client owns. So that could be any real estate, so that's a house or land, cash, any vehicles, any shares, and then we'll also look at the assets of any person who helps your client financially, unless of course the client is in dispute with the other person. So if the client's applying for family law, parenting and property, for instance, then we won't look at the assets of the other person in that dispute. But it depends on the situation and what the client's applying for aid for. So there are some assets that are exempt from our assets test, and it's probably there is a lot of different things that we will look at and take into consideration. So if you want more information on that, I really do encourage you to go to that fact sheet about can I get legal aid. But some things, for instance, that are exempt are we allow clients to have a certain amount of cash in their bank accounts. So at the moment, our policy is you can have up to $2,000 in cash that's deemed exempt. And there's some additional allowances as well. But all of that information is contained in that fact sheet. It's written to the client as an audience, and it's a really good fact sheet in plain language, explaining what our tests are and what we look at. So I won't go into all of those exemptions today.
Yes.
Because there is quite a few.
Yes. But people can have a look at that on the fact sheet, and it's probably good if you're helping someone to actually have a look at that yourself, just while you're working through the form. Best to put things into the form though, because the grants officers know which assets are exempt and they will exempt it. So put everything in.
Put everything in,
Yeah.
Fill it out as best as you can with the information you have, and our assessing officers will have a look at it, and they'll make an assessment against our test.
Yeah.
So yeah, there's different values for different things, and I definitely encourage you to go to that fact sheet.
Yeah.
But ultimately, after we've made an assessment under the means test, there is a consideration as to whether an applicant should contribute towards their legal fees. So we essentially have a few decisions to make under the means test. It's one, is the client financially eligible under the income and assets test? Yes or no? If they are they eligible without paying a contribution towards their fee, or with paying a contribution towards their legal fees? So sometimes applicants who are approved legal aid funding will be requested to pay a contribution towards their fees. So then we're going to our next slide.
Yeah. That's the table, right?
That's
a sliding table. Very confusing for people, but if you get the opportunity to have a look at that, once you work your way through it, it becomes a bit clearer.
Yeah, and the way I like to explain to people, so this is our income test, this table, and this looks at a number of things. So it's split into three essentially. You're a single person. If I go from the bottom, if you're a single person in the workforce, that bottom part of the table is the income test for single people. If you're a couple, one in the workforce, the middle section is for those category of clients. And if you're a couple both working, the top section applies to that category of clients. And then you'll see you have a number of children. So as I explained before, depending on how many, we factor that in to our income assessment. If you've got children, you can earn a little bit more. And then the next part of the column goes into, will tell you whether you're eligible for legal aid without paying a contribution towards your fee. And the next one is what the maximum income threshold is that you can earn. After that, essentially the client's not eligible for legal aid. It is important to note we look at the client's gross weekly income. So that's where the pay slips are really important, because people normally look at their income as what they receive in their bank account. We do look at the gross weekly income, so pre-tax. And then the contributions we charge are in that sliding scale in that table.
And if you have a client who has been assessed as having to pay a contribution, they'll get a letter telling them that, won't they?
Yeah, so they'll get a letter from us saying that they've been approved legal aid, but they need to pay a contribution towards their legal costs.
Yeah, and once again, that might be something that you might want your client to call us so that we can help explain that. Yeah. Special circumstances, Leanne. We do have some clients who, for example, might need special consideration just because of their particular circumstances. So we do have the capacity to consider special circumstances, and there is a section on the form for people to actually tell us what their special circumstances are. So really, I mean, if you were helping someone to fill in the form, you'd really want to make sure that we detail all of the special circumstances for that client that you think or the client thinks should be taken into consideration when we're doing the assessment. But again, we have very strict criteria about those, and again, they're on our website, right? Yeah,
they are. And it is important for the application to be completed in full. You know, we common get things on the form where the client's in receipt of a full disability support pension, but they don't tick that they've got a disability on the form. So things like that. If you can provide as much detail as possible on the application form about any disabilities or disadvantages your client has, it would really help us, because there are some things that our officers have discretion about. So for instance, under our assets test, if there is an applicant who doesn't meet the test, but they do have disadvantages, disabilities, that kind of thing, we can apply special consideration to those applicants. And that's detailed in the means test. So that's our means test special circumstances guidelines. So you can find out more information on our website. And that really relates to clients who don't meet our assets test but should be given special consideration.
Yeah. We've set out a few of the circumstances there, but really, I guess the message is make sure that you settle out all of those circumstances, individual circumstances for your client, so that the grants officer can consider them. Okay, so that was the means test. I don't know if we've got any questions about the means test as we were going through.
We haven't had any come through yet.
No problem, but if you do have a question, you can pop it through. But the means test is only one part of the story, Leanne, isn't it?
It is.
Other part of the story is the merits test, and this can get a bit tricky too. So talk us through the merits test.
So the merits test is applied to some cases. Our policy manual will detail the cases that it doesn't apply to. But basically our merits test looks at, or there's three components of our merits test. I think the next slide might go into that a bit more, but you can see on the picture on the slide, there's a reasonable prospects of success test, there's a prudent self-funding litigant test, and there's an appropriateness of spending limited public funds test. One part of the merits test, so in the slide, we talk about whether a person's case has legal merit and a good chance of being successful. That's our reasonable prospects of success test. The full test is in our grants policy manual. So for the lawyers that are online today, I would encourage you to have a look at that and read through our merits test. It's only a one pager really of which outlines the test, but it is another fundamental test for our application process, and it doesn't apply to every single matter. I can't go into which ones it does and doesn't apply to, but the policy manual sets out when it doesn't apply.
Yeah. Yes.
We have actually, so I'm going to interject just so we have actually had one really quick question.
Yes.
From Insist.
Oh, yep.
So where a client has to pay a contribution for their matter,
Yes.
are the contributions a one-off payment or multiple payments?
Normally, so I think the vast majority are a one-off payment. There may be a situation where we split the contribution across the stages. That doesn't happen very often. So normally it's a one-off payment. And we do have some rules in place. So if the client's applying for multiple matters at the same time, so you could be applying for domestic violence and family law, different grants of aid, we only charge one contribution. We don't charge a contribution on both files. So there are different rules. There are rules for that, and normally within a 2-year period, will that contribution last across the file and any new files that are created post that. But yes, normally one contribution for over a period of time for the client.
But I'm not sure if the question is getting to that or to this, Leanne, which is I've got a contribution I've got to pay, it's $1,200, I might want to pay it in instalments.
Yes.
That's possible too?
Potential, that's a complicated question.
Oh, sorry. Oh, well, that's why we're here, for the complicated question.
So if we have any preferred suppliers online, I guess that's a decision for the firm as to whether they would allow the client to pay the contribution in installments. Because what happens from a grant of aid perspective, when we have provided the grant of aid on condition that the client pays that fee for preferred suppliers, that amount is automatically deducted from your account. So when you go and claim the invoice, we will deduct the contribution there. So there's an expectation that preferred supplier firms will collect the contribution.
And talk to the client about that.
Yes.
And we'll get into in a minute preferred suppliers and in-house staff, but some people may get a lawyer who's employed by legal aid, and we won't start work until the contribution has been paid. So it is a very important thing for clients to get paid as quickly as they can to get the matter going.
Yes.
Yeah. Hope that answered the question. We did both question answers there, so
excellent.
That's all good. Any other questions on that?
Nothing coming through at this point. So
okay, great. So now that slide there, Leanne, that's sort of like a simplified explanation of the merit test. So they're the three sort of aspects of the merit test. If people want to understand it or know it a bit more, it's the website.
Yes.
So we've covered means, we've covered merit, and now we need to talk about the third thing, guidelines. And I'm not sure that many people know about the guidelines. I mean, maybe they are if they're familiar with the work that we're doing, but for people who are applying for legal aid themselves or for support people who are helping people, the guidelines is probably something that you might not be expecting. And this is really where these are the guidelines that we really don't have much discretion over, do we?
Correct. Yeah. So our priorities are set by the state and Commonwealth government, and when they give us the priorities, and the guidelines are what we use to assess whether someone's eligible for legal aid or not. Our guidelines are determined by our board, so they're not something that are often changed. They can be changed, but they're more difficult to change.
Yeah.
And if the government provide, depending on the government of the day, we can get different changes in priorities as well. So the priorities can shift depending on the government at the time.
So it's probably worth just checking the guidelines if you haven't, if you haven't applied for legal aid for a while or you've never applied before. It's probably a good idea to check the guidelines.
That's right.
Because that will tell you whether that's something that we fund or not.
Yeah, and it sets out, so our policy manual sets out our minimum criteria for funding. So it's quite a short document to read. So if you are someone who does legal aid work, I definitely encourage you to have a look at that. It is split into crime, family and civil law, and also whether it's a state or Commonwealth matter. Because we receive funding from both the state and Commonwealth government. So yeah, it really depends on the matter that you're applying for aid for. I mean, really common ones are criminal law, matters that are in the magistrate's court, summary pleas. There are guidelines for summary pleas, and there are different guidelines about domestic violence matters. So it really depends what you're applying for aid for and what criteria we use. And we don't have enough time today to cover them all.
We don't. People should just put in the application, right? And then we'll assess it.
We'll assess it.
And once we've gone through the means, the merits and the guidelines, the grants officer will come out with a decision.
That's correct.
And that decision will either be to provide a grant of legal aid or not to provide a grant of legal aid. Obviously we get a lot of clients who might not be happy with the grants decision. So what can clients do if they're not happy with the decision?
So if your client isn't happy about a decision that we make, and that doesn't always have to be a refusal. So that can be where we've made an approval on the condition that the client pays a contribution, for instance. So your clients can request a review of a decision that we make. It must be in writing. In exceptional circumstances, we may accept it verbally, but that's normally where clients in prison, there's a timing issue, and we need to make it, and we need to make a decision quickly due to court dates. But generally speaking, if you're seeking a review on behalf of your client, or your clients come to you unhappy about a decision that we make, there is an option for them to seek a review. And we have a number of opportunities for reviewing decisions that we make at Legal Aid.
And there's no form for that? Like a client sending an email saying, I'd like this decision reviewed is sufficient for the review?
Correct. At the initial stage, there's no form, so they can send us an email or send us a letter letting us know why and I think really what we need to know is if they can give us a file number, that would be really helpful. Their full name, why they're seeking a review, what part of the decision they don't agree with, and then one of our assessing officers will have a look at that. And make another decision, essentially.
And if you have a client who would like a bit more information about the review or needs some assistance to go through the review process, they can call that number, and I haven't got it in front of me. It's the number for people who've already applied for legal aid. So that grants number.
Yes.
Yes, it's I don't know off the top of my head. I probably should.
It's right. 1300 383 900.
Thank you.
And we'll share that in the email.
Right. Yes. So if you've got a client who's not happy with the decision and wants to talk through how do I do a review, they can ring that number and we'll talk them through how to do that. Great.
Yeah. So and there's a number. When I say there's a number of opportunities. So when a client does request a review, there's several different pathways it can take. So normally what will happen is it will go back to the person who made the decision so that they have an opportunity to reconsider their position on the case. And a lot of the time we see when a matter's been refused, we get additional information from the client or the solicitor, which can in a lot of cases change the decision that we made. So if you're seeking a review, please provide us with lots of information about the matter, so that we can reconsider our position.
Yeah.
So we'll normally go back to the original assessing officer, and if they don't change their decision, so that being the decision remains refused or the contribution remains in place, they will then automatically send that through to a senior officer to review the matter. So the client doesn't have to seek a further review after a reconsideration by the assessing officer. It will automatically flow through to a senior officer to consider the matter, and that's a senior officer, and we look at that as an internal review process. So at internal review, where we will send a letter to the client and also the solicitor, if there was one that lodged the application for aid, detailed reasons outlining why the matter, why we've made that particular decision. So it's a lot more thorough than the initial decision you'll get from our system. And if you're still unhappy, the client or you as a solicitor or social worker are still unhappy with the decision that we've made, there will be a form attached to that letter which allows the client or their solicitor to seek an external review.
And again, we can help people with that. So if you just want to call through and talk, that's a little bit more of a formal process. It goes to a panel, well, it goes to someone on our panel of experts who will look at it, who's not employed by legal aid. So it is a full external review, but there is a bit of paperwork to do with that one. So people really should call that number if they want to go to, if they've been through the internal review process and they want to go to external review, because they probably will need a little bit of help with that. Great. All right. Now, I think we've got a, we skipped ahead. Okay, so that's what happens. Get the grant of aid. And the important thing is that letter, which is sent to the client, will actually explain what the grant of aid is for.
That's right,
Leanne. So it's very important that people read the letter, because they may get approved for a different thing to what they asked for, potentially.
Potentially, yes. And the letter will outline it. It's what we've funded.
Yeah.
So when we grant legal aid, that isn't, depending on the matter again, sometimes we've funded in stages. So, and probably the easiest example would be in a criminal law case where the matter has to go through the magistrate's court for a committal and then to a higher court for sentence or trial. We grant funding for the magistrate court proceedings first, and then at the higher court stages, another grant of aid will be considered.
Yeah.
So the initial the grant of aid approval letter to the client will outline what we have funded. So it can depend. Whereas for a magistrate's court summary plea, we'll fund it for the plea.
Yeah.
So there won't necessarily be any further requests for funding required on those files.
Yeah. And we see it quite a lot in the family law space, don't we, Leanne, where people might apply for going to court for their parenting orders, but actually they need to go to mediation first. So we might fund the mediation first before they can go to court. So it is really important to check that letter. And again, if your client or you need help to understand the letter, just call that number and we can talk you through it.
We do have a poll now, but I'm just going to quickly throw a question that's come through,
Sure.
because it's appropriate for what was covered. Do any of the 3 tests carry more weight than the other?
Oh, good question.
No.
Okay.
So if all 3 tests apply, the client will have to meet all 3. So they don't carry any more weight than the other. They're equal tests essentially.
They're all required.
They're all required.
Another question is, why does legal aid not take into account like potential liabilities or expenses regarding the grants that the client might have? Is that something that's considered?
So we have, at Legal Aid Queensland, we have a simplified means test. And we at the moment we don't look at debts and liabilities. We look at the gross weekly income for a client. Now that being said, if a client has significant debts and liabilities, and it's something that a grant of legal assistance should be provided for, the client can always seek a review. There's potential for discretion at the higher levels to consider, but that would be considered on a case-by-case basis.
But put it in. I mean, I think my advice would be put it in. And if there's some particular circumstance, so for example, you know, your client may have money in their bank account because they're saving for bond and they're about to move, put that in, because that, you know, it is something that may be able to be considered. So I would say if there are, think of it like the special circumstances. We've got room on the form for you to detail all of those things. So I would err on the side of putting it in rather than leaving it out. Yeah.
Okay, thank you. So just breaking now, we may go 5 minutes over with this webinar.
Oh, sorry.
Which is 100% fine, because I can tell we're getting lots of great questions coming through. So just for everyone who's watching, if you do need to leave at 3 on the dot, just know that the Q&A section will all be included in the recording. So if you miss out and you have to leave, it will still be captured. You can watch it later. But I'll just jump in with this last poll now.
All right. Well, will we skip the poll? Because why don't I just answer the question?
Yeah,
and that'll
that's
save
perfect.
time. It's false. Both parties are able to access legal aid. I think this is a common myth that people have. That only one person's able to get legal aid. We're very lucky. We have a wonderful network of partners who work with us, our preferred supplier network, and thank you to any of our preferred suppliers who are on online today. We wouldn't be able to deliver all of our services without you, and they assist us to make sure that everyone who's eligible for legal aid gets a grant of legal aid. Now, what that may mean is one of you may have a lawyer who's employed by legal aid, one of you may have a lawyer who's employed by a preferred supplier. We still pay for everything. There's no disadvantage to anyone. And if you have another party in your legal matter who's legally aided, that shouldn't be stopping your client from applying.
Great, thank you.
Okay, quick top tips. We've covered most of them. Hey, complete your application. If it's complete at the beginning, it will save a lot of time. It helps us process it more quickly, and it stops that backwards and forwards between us and the client or you around getting the information. So it is time intensive, but it pays off in the long run, doesn't it, Leanne, to just really do that complete application at the front if you can.
Bank statements versus transaction lists. That's a common one. When the client sends through their transaction list, we can't normally see the balance that they're holding in their account. So send through the full bank statement. We require all of the pages of the Centrelink income statement. Sometimes we only get the first page. So normally they're a couple of pages long, if not longer. But generally speaking, I think they're normally 2 pages. On the form, there's a little symbol, attach a copy of. Look out for that symbol. So if there's one of those symbols on the form that where you've completed a question, make sure you attach the copies of whatever documents the application form is asking for. Otherwise, there's potential that we will then ask for that at the end. If the Office of Public Guardian or Public Trustee are appointed, if there's a QCAT order appointing a substitute decision maker, please provide us with copies of those orders, particularly as well with the Public Trustee. If they're managing your client's financial affairs, they will hold all of the details about their assets and liabilities and income. So please provide those statements as well. If your client needs ongoing help from you or another person, complete that client authority form.
Yeah.
That way there's no delays partway through the process for us to get the client to fill out that form later down the track. And probably my most important top tip today is don't wait until the court date to apply or get your information in. Apply as early as you can. so that you can avoid any delays and secure your funding prior to the next court event. I know sometimes that's not possible, but if you can get it into us as early as you can, that will avoid disappointment with delays. We do try as best as we can to get decisions out to you as quickly as possible. Normally the turnaround time is within about 10 business days or less from the time you submit the application form. But yeah, so if you keep that time frame in mind, please apply as early as you can, and hopefully we'll get a decision to you before the next court event.
Great. Client hasn't heard from us. A couple of things that you can assist the client to do. Obviously, give us a call. See the duty lawyer and get an adjournment and just explain that they've made their legal aid application, and the duty lawyer will do that for them. If you haven't heard anything back for a little while, it is probably because we need some extra information for you now from you or the client. So if we haven't been able to get in touch with the client, as Leanne says, we may have sent a letter, which, as we know, may take a little bit of time. So if after the 10 days your client hasn't heard anything, they probably do need to give us a call, and we'll be able to give them an update about where things are at. Great, questions?
That is the end of your presentation. So let's have a look and see what questions we've had come through. Just bear with me as I scroll through.
And I see all those, all the contact details and the numbers and everything are on that last page of the slide. So that's probably helpful.
So this is a bit of a long one.
Okay.
More and more we're finding it is difficult for people to access up-to-date bank statements, e.g. ANZ only provides statements twice a year and will charge a fee if required between the states. Is there a way that the last application is acceptable, for example, lodged at the end of October with the statement for June, or is it a matter of screenshotting all their transactions?
And look, I guess they'll have to be assessed on a case-by-case basis, unfortunately. If you can get us a most up-to-date statement, that's great. I do know, though, that you can get, like, some clients, depending on how you set up your statements, you might have 6 monthly statements, and by the time you apply, your statements might be 5 months old. So I think it really depends on the length of time and how long's passed between the statement being delivered to when you're applying for legal aid. But you can print it. See, it doesn't have to be one printed by the bank. You can print it from so if your client has online banking.
Some of them let you do that date range, don't they?
Yes.
So you can print that. Really, the important thing that we need in the statement is, you know, showing us a period of time, recent period of time, that it's got the client's name and the bank BSB and account number, and it's got the balance. Correct. Right? I mean, that's really the 3 essential things. So if you can print something out that's very recent that's got that on it, and that's all you've got, attach it, and if it's not good enough, we'll let you know. But that's probably likely to be good enough.
Yeah, and if that's all you have too, then let us know that on the form.
Yes.
Because we can't read your mind as well. So if that's the best you've been able to get, let us know when you submit the form, and it might be then we can consider that as well.
Yeah, that's right.
Thank you. So another, and I don't know if you'll be able to answer this, how long are reviews taking to process? Is that, it depends?
External review? Internal review. It's a bit tricky.
Again, yeah,
so
it's a bit general. So
we've got time frames around it, though, don't we, Leanne?
Yes, normally when the matter goes to the original decision maker, they're normally turned around pretty quickly. Internal review can take a little bit longer. So if the assessing officer hasn't overturned their decision and it goes to that senior officer, they do take a little bit more time. I'm sorry, I can't give you the time frames today. I don't have it offhand. But I think it can, the more complex the matter is, they can take a bit longer too. But we do try to prioritise matters based on court dates.
Yes.
So if we know that there's a really important court date coming up, so not a first return date, but a trial, like a district court trial, Supreme Court trial,
Yes.
family court trial that's been in court for
Interim
years,
hearing. Yeah, that's right.
interim hearing, we will prioritise those matters. So priority is given to the next court event. And also we will look at the date received too.
Yeah.
So yeah, some things can jump ahead due to those court events, and we will prioritise matters accordingly.
Yep. Just a reminder, there's a couple of questions come through that have asked about a particular client's matter. So for example, Krista Lee, we won't cover your question now, but I will follow up with you afterwards and we'll get an answer directly to you. So we'll give you an email just after this about your client and needing an urgent application. So I'll just think one more just snuck through. Let me just have a look. Okay, what are the options for a client who has received funding for a lawyer, but the lawyer allocated is not being responsive, missing deadlines, or is not helpful? Is there an option for them to change lawyers? How does that work?
So generally speaking, clients don't have a right to choose their solicitor. We are talking about public money here. So when we allocate a grant of aid to a lawyer, that costs us money. So we don't take decisions to transfer funding lightly. If it's a preference type thing, that may not be approved. Things that where we will transfer a file to a different lawyer are where there's a conflict, where there's an irretrievable breakdown in the relationship between the client and their solicitor, where the client may have relocated and they're a significant distance away from their appointed firm. They're the kind of things that we will consider when we get a request for a transfer of solicitor from a client. But again, we are dealing with public money here, so we do encourage our clients to talk to their lawyer if they're not happy with the lawyer that they've been appointed, and a lot of the time the lawyers that they're dealing with, there'll be multiple lawyers within the law practice that they've been appointed. So we encourage clients to go and speak to the principal of the firm if they're having an issue with their lawyer. If they can't resolve the issue, then of course client can come to us and request a transfer of solicitor. We will want really detailed information about what issues the client's experiencing to make that kind of decision. But we do try, if we can resolve it, we try to, because every transfer costs us money.
Okay, thank you. That's probably the last question we'll get to today. So I'll just do the wrap up, and if anything else pops through that's relevant, I'll let you know. But I might move on now to just reminding everyone of the key phone numbers for legal aid. So the first one there, that's our call centre, 1300 651 1188, for people who need to call to get legal information about their situation. We also should mention we have a priority phone line for Aboriginal and Torres Strait Islander people. So if you have a client who's a First Nations person, if they call that phone number, their call will be placed in the priority call queue. So I encourage you to use that phone number. And the last one listed there is that one for people who've already submitted an application, want to check the status of that. Yep.
And probably the only other thing I'd add, if you're a lawyer and a preferred supplier firm who partners with us, you'll have a direct line to your grants team. So if you'll know that number, give that team a call rather than ringing the 13th.
Oh yes,
yes, absolutely. Really quickly, just to remind you all that our Legal Aid website is a fantastic resource for you all. It has heaps of free publications and legal information on a wide range of common legal issues. So I encourage you to go on there. Those publications can be downloaded and printed. You can also order them. They're completely free with free delivery. So if you want some of those in stock at your service, please feel free to go on there and place an order and they'll be delivered to you.
Yeah, that's actually great. They are free.
It's a fantastic service.
Yeah,
it really is. Please make use of that.
Yes.
We do run monthly webinars. We're hoping to run one in November. We're just checking the availability of our speaker who's been unwell. So hopefully a youth justice topic, but to be confirmed. So watch this space. If you're on our mailing list, we'll let you know ASAP if we've got that confirmed, and we'll open up registrations. As I mentioned earlier, we do caption all our webinars. We put the recordings on our YouTube channel, which are all publicly available, and we'll send you a link to this one after the session. And feel free to follow us on any of our social media channels, Facebook, LinkedIn, Instagram, and Twitter, because we promote all our webinars on there as well. That's it. That's the end of our presentation today. So I just want to say,
Thanks,
Katrina, and again, thank you so much for making yourselves available. I think that was a fantastic, really useful topic. And thank you everyone for joining us, and we hope to see you at the next one. Thank you.
Bye.